Although the courts were quick to reinforce the right to information by way of its decisions, implementing a legislation on the right to information was something that was far-fetched. It had several impediments in the course of legislating the right to information. It is known that secrecy is one of the major reasons that bureaucracy works and functions. It has been held that power can be used at its best when it is kept secret, when information is kept confined to very few, those who govern. This was what Weber believed in his theory of bureaucracy. But however, in a democratic setup, there is a rationale for a requirement of an open and fair, transparent government, which has been held across the international spheres. In Indian legislative scenario, there were several impediments to implementing the RTI Act. One such major impediment that was there was the section 123 of the Indian Evidence Act of 1872, wherein it was provided that no one shall be permitted to give any evidence derived from unpublished official records relating to any affairs of the state except with the permission of the officer at the head of department concerned, who shall give or withhold such permission as he thinks fit. Section 123 of the Indian Evidence Act, although it did not directly impede the implementation of the RTI, it gave the power to the head of a department or an officer of a concerned government to withhold the permission for grant of copies of such records. Now, the right to information involves getting an access to the data. With section 123 of the Indian Evidence Act giving the power and the discretion to the officer of the concerned government department, created a major hurdle as to the dissemination of the information in its very first instance. Secondly, we move on to the Official Secrets Act of 1923. The Official Secrets Act of 1923, in an attempt in 1977, the Morarji Desai government had constituted a working committee to look into the requirements of the necessity for the Act. It was concluded by the working committee, as discussed earlier, that the Official Secrets Act required for the government to function in a peaceful manner so as to punish the offenders related to espionage. The Ministry of Home Affairs, Finance and Defense labored for months to recommend that the Act of 1923 should be retained without any change. The Official Secrets Act of 1923 was one of the most draconian laws which are still in force in India. It was the legacy of the British Raj and had often resulted in great miscarriage of justice and had blotted record books of judiciary in its progress. Several leading jurists and scholars have called for the repeal of the Official Secrets Act, but till date it continues to be in its very existence in order to combat espionage as it is put forth by various authorities. However, it is pertinent to note that various commissions and civil body groups have recommended the ousting or repeal of the Official Secrets Act. In fact, the Second Administrative Reforms Commission, headed by Mr. Veerappa Moily, had also recommended the repeal of the Official Secrets Act on ground that espionage and spies can be punished under various other enactments such as the Navy Act and others, which has adequate provisions for the same. Despite several attempts, including in 1948, wherein the Press Law Inquiry Committee required that the application of the Act must be confined only to matters of national security, the same has been unheeded. More than the advantages of the rationale for the continuance of the Official Secret Act, it is pertinent to understand that there are two infamous cases that show across how the Act has resulted acting as an impediment to disclosure of information. On one such instance, wherein there was a strong movement against the construction of the dam in the Sardar Sarovar project, was the Official Secrets Act had been utilized to prohibit the entry of journalists into the area where the massive displacement was taking place on account of the construction of the dam, which was one of the largest dams and had left several thousands of persons displaced from their inhabiting locations. Severe public debate and dissent was looked across, and the actions of the government were frowned upon for utilizing the Official Secrets Act of 1923 for suppression of information.